want us to understand each other.
Yes.
You've just said the applicant has failed to dismiss your application.
Application for it's an application to intervene, my lord.
It is a court that dismisses the application, not the applicants.
They are grounds, my lord. That's what I mean. So the grounds which they have put forward is not sufficient. They are not sufficient enough to dismiss my application to intervene. So the critical question, my lord, which must not be overlooked in this court is if this court grants an order to force the repatriation of the women of our former late president, and if such order triggers civil unrest in Zambia, how will the rights and safety of Zambians, including myself, be safeguarded? And answer that, my lord. I'm going to refer you on the supplementary affidavit of the Attorney General at paragraph 14.2, where it is stated. Let me start with 14.3, where they say, nevertheless, under this circumstance, there cannot be any doubt that a failure on the part of the applicant to ensure that the late president be accorded a state funeral will further steer controversy and may lead to civil unrest. So if that violence, my lord,
Order, please.
if that violence are to happen, my lord, it means I'm part of it. I'm a Zambian citizen. I need peace, but do we need to force the family of the late president? We don't have to do that, my lord. We have to do that through dialogue. Our political leaders, traditional leaders, and the church.
Sorry for a moment, Mr. Kafula. Please let there be order here. Those who are talking when Mr. Kafula is addressing us, I may be forced to say you should move out of the court. So please behave yourselves. Proceed, Mr. Kafula.
So, we don't have to force the family. The family must agree by themselves. No, this court must not force them to repatriate the remains of their loved one.
Yes.
They have to negotiate with them. They can bring neutral parties, my lord, like our chiefs. We have the church leaders, church leaders, and NGOs. People who are not worshipping government. If you bring people who worship government, you can't agree because their negotiation cannot be fair. So we need fair people to negotiate with the family. We can't force them. This court must dismiss the application for the applicant.
But Mr. Kafula, sorry to interrupt you. In your application,
Yes, ma'am.
one of the orders that you are seeking is that the body should be repatriated, and you've also asked that.
Can I just clarify? I said on the condition of the family, which I mean, the family has to decide.
All right.
Put there on the condition of the family.
Okay,
so
hear
the
you.
government has no part to force them.
Yes.
The family must agree. If they don't agree, they must find a better way. Have them agree, not to force them.
Yes, you've made that point.
Thank you.
Yes.
Then, if you go at paragraph 14.2 of the supplemental affidavit of the Attorney General, it is on the bundle K42.
Yes.
There's further important consideration. Opposition leaders have accused the present government, led by President Edgar of ill-treating President Lungu and seeking revenge against him. The government has denied this accusation. But this is a mere denial. They have admitted that they refused to go seek medical attention. There is a dispute. They have agreed in their papers that they stopped him from taking exercises, those health activities, so that he can keep health. They refused. So, my lord, the opposition, they are correct. If we force the family, there are many people now Lungu. They can cause violence, my lord. This thing must be solved through dialogue. People must talk. The government are bullying the family. We can't allow such. Why must somebody bully them? They refuse to help them when they needed help. Why must they help now to buy a coffee?
Sorry, can I just ask one thing?
Yes.
What is your direct interest in this matter?
The interest is that if the order is granted in favor of the government, the people can arise and can cause trouble, and I'm affected for that. So
are you acting on behalf of the people in Zambia, or what is your direct interest?
I'm a Zambian citizen, my lord. So if there is violence, if there's unrest, you remember we are here in South Africa in 2021 when people they caused that, and you know how many people, there's how many businesses which closed, how many billions which are lost. So our country is very small. If they are to do that in my country, even myself, I am affected. So the applicant, they are relying on essay writing for disabled association versus regional grant claims. Let me read what the Constitution states. It said, if the applicant shows that he has some right which is affected by the order issued, permission to intervene must be granted. Once the applicant for intervention shows a direct and substantial interest of the subject matter of the case, the court ought to grant leave to intervene. I submit, my lord, that I have direct and substantial interest in this matter as a Zambian citizen, deeply concerned with potential for civil unrest, as acknowledged by the applicant in their answering affidavit, in their affidavit, supplementary affidavit at paragraph 14.3. The applicant further stated that they further stated that would otherwise absent court intervention, there are no other losses which the applicant is able to make use of, which would ensure that Mr. Lungu's body is repatriated back to Zambia. I say, my lord, this is not correct. If they follow a proper dialogue, which
The merits now, we just assessing your application to be joined in the proceedings. Do you have further submissions?
no, I have no further submission.
Thank you very much, sir. Advocate Steele.
May it please you, my Lord Panedi, I carefully listened to Mr. Kafula and the sentiments that he expressed. Of course, dialogue is preferable, but that doesn't give him the standing that he purports to argue he has. What we did is we gave notice of a legal point that we will raise that you find in case lines on section W1 and on W3. What we say is that the applicant in the intervention application never or cannot demonstrate that he has a direct and substantial interest, and he also cannot demonstrate that the application was not made frivolously or that it was made seriously. And to demonstrate the frivolous nature of the application, one only needs to go to the application itself, where the relief that he seeks, there are 9 orders. The 5th order is dismissing the application, and I will deal with that. All the others concern issues that the courts in Zambia clearly has to deal with.
But he has considered that point, Mr. Stoop. He considered that point.
So, if that is conceded, there's simply nothing left but to demonstrate that he has, in fact, no direct and substantial interest. And I only need to take you to the Constitutional Court matter, essay writing for the Disabled Association, where the test is laid down. No doubt, my lords, my lady, you know what the test is: a direct and substantial legal interest that will be affected. And whatever the outcome of this matter may be, none of Mr. Kafula's rights or interests will be affected. He may still approach the courts in Zambia to seek the relief that he says the court should grant and which he considered can't be granted. None of his rights would be affected. So, in the heads of argument, you may have had sight of it. I apologize, it came fairly late in the day, but it is in section ZA, where the heads of argument in the intervention application appear. And I refer to the matter that the intervention applicant relies on. It's the Seguira matter versus Standard Bank, just to illustrate why this application can't succeed. And in the Seguira application or matter, the court granted intervention under circumstances where it concerned the rights of a spouse married in community of property to the joint estate, the communal residence. So what we say is Seguira serves as an example why this application can't succeed. We submit it should be dismissed. The applicant is in person. In the heads, we indicated that we would seek costs. We will not assist with that.
Thank you.
The court pleases, my lord, my lady. The respondents indicated that it will abide by the court's decision with regard to the intervention application. If we don't oppose it, we don't support it.
Okay. Thank you very much. Okay, the court will adjourn for some few minutes to consider this application. Court adjourns. You have carefully considered the application by Mr. Kafula, and my colleague will give a judgment or a ruling on that application.
The applicant, Mr. Kafula, is asking to be joined or intervened in these proceedings. He has raised or is seeking about 9 orders. He has correctly conceded, and we're thankful for that most of those orders this court can't grant, or basically the whole crux of them this court can't grant, because this court cannot intervene in Zambian law. The test for intervention is whether the applicant in this matter has a direct and substantial legal interest in what the order is going to be. We cannot find, because of what the orders he's seeking, that he does have a legal right or interest in what order we will give, and that his rights, legal rights, will be affected. Therefore, the application for intervention is dismissed. No order as to costs.
I agree.
I agree.
Thank you.
May it please you.
Thank you. Yeah. In respect of the main application, we have decided that we would give you 15 minutes uninterrupted, so that you can just address us, and thereafter we will raise whatever issues that you want to raise with you. Advocate Stewart, you may proceed.
Thank you, my lord. We prepared a
So,
bundle.
Mr. Kafula, you are excused if you want to leave the courtroom. If you want to sit and listen to the proceedings, you are welcome.
My lord, my lady, we prepared a bundle for the court's convenience. That's the authorities we refer to in their heads. We handed a copy to our learning friends. What the applicants seek is the deputation of the body of the late President to Zambia, and we contend that the applicant has a clear right. Why is that relevant? Because it's interdictory relief. The clear right we submit are based firstly, to an extent, on the wishes of the deceased, and we will take you to the founding affidavit where the respondents, in fact, and I may perhaps just clarify when I refer to the respondents, my lords, my lady, I refer to the first to seventh respondents. The eighth respondent, who is the undertaker, doesn't play any role. So a reference to the respondents essentially is a reference to the family. What they stated is that the deceased, his wish was upon his death, he should be repatriated, but he should be taken by private charter. That's what they say up front. Then there were a number of engagements, and following those, there was a clear agreement reached, and that agreement entailed that the body would be transported, he would be given a state funeral, and it is that agreement that we say provides the clear right that the applicant says exists. What we also now know is that that agreement, which is contested by the respondents, was repudiated. And if that is the case, on the respondents' version, that there is no agreement, we say that the law relating to burial rights in any event affords the applicant the clear right that they seek to put forward. But there is a complicating factor, and that is that what we contend is that there is a foreign element present, and that the Zambian law should apply, considering all the connecting factors, and I will deal with that. And if we look at Zambian law, there is clear judicial precedent stating that in the case of a person of significant national interest, the wishes of that person must yield to the broader public interest. So what we say, there was an agreement, and in Zambian law that agreement is binding and is enforceable. In the alternative, if there's no agreement, then in any event, the law relating to burial rights provides for the applicant to be able to afford a state funeral and the burial in Lusaka. In the event that the court should find that the South African law should apply, the result would be the same. We say there was an enforceable agreement. We can even spell it out in Latin, pacta sunt servanda. There was clear agreement between the parties that the body should be repatriated. And in South African law, there is also authority to the effect that the court should approach the matter based on fairness, on the circumstances of each case. And in the bundle of authorities that I just handed up to your lordships and my lady, we will also refer to a matter where the court stated, in a case of a customary law marriage.
Just for the sake of clarity, bear with me. The bundle of authority that we handed up, is it also on case lines?
It's been uploaded to case lines, my lord, yes. That in a matter that I will refer your lordship and my lady to, the court found that where it concerned a person, it's Mr. Tsambo, of significant national interest, or an important person who was being granted a funeral by the province, the court said that the wishes of the family must yield to the broader public interest, which is exactly the same as is the case in Zambia. Those, in broad strokes, are the submissions that the applicant will make. There is also then interlocutory applications that I will deal with. The applicant is aggrieved by what it contends are instances of, let's call it political grandstanding on the part of the respondent, where they included allegations in the answering affidavit that are vexatious and scandalous. That will be dealt with. There is also then an application for condonation on the part of the respondents to bring a counter-application. We will also briefly deal with that application, which we say simply has no merit and in the interest of justice cannot be granted. If I may...
The respondent also raises can the government of South Africa just be removed or not? Are you also going to address that, or has that been settled, or with the amendment that you brought?
I would be surprised if the respondents persist with that submission.
I think so would we.
There was proper notice given that the notice of motion would be amended, 2 paragraphs struck from the founding affidavit. There was no objection raised and the amendment was properly effected. What we say, my lady, is that the department, DIRCO, so to speak, in colloquial language, has an interest in this matter, clearly, but it is not a legal interest. And it is only for that reason why the department and the minister was cited. And for reasons that I need not dwell on, it was decided to remove the minister from as a party, as a respondent, and the court order clearly gave the minister the right to intervene if the minister felt that it should be heard. It had the opportunity to do so. So I submit that there is no case or question that the department could have been removed, and it is not a case of non-joinder with respect. If I may then turn to the facts, and first start with the wishes of the deceased. What is significant is what the respondents themselves state, and the reference you will find on case lines K18. It is the supplementary founding affidavit, paragraph 7.6. I'm just quickly going to quote from that. 7.6, the family objected that the late President Lungu stated out his wishes before he died, which were that, and firstly, his remains should be repatriated back to Zambia in the same manner that he had travelled to South Africa.
I'm sorry, you've lost me. You referred to K, didn't you?
K18.
K18. Thank you.
And then 7.63, in the event that he was accorded a state funeral, his successor should not be allowed to attend it. Now this comes from the respondents. So the important point is that it was never the late president's wish to be buried in South Africa. That's simply not on the papers. And that's what the respondents now seek to do. So what they want is, in effect, to go contrary and against the wishes of the deceased. What they also said is that in the event that there is a state funeral, his successor should not be allowed to attend it. Now that issue was dealt with specifically in the subsequent meetings that were held between the applicant and the respondents. And it is from those meetings that a compromise agreement flowed. And that compromise agreement, important entails that if the president is present, he can be there, but he must be there when foreign dignitaries are present and also when the funeral takes place where heads of states are. And I will get to that and I will take you to the relevant portions. So the first important point dealing with the wishes of the late president, there is no indication that he wanted to be buried in South Africa. That's a starting point. Secondly, his wish was to be repatriated. In the founding affidavit, the meetings that were held then are set out. The first one is a meeting on the 10th of June. That was in City Lodge. You find in the supplementary founding affidavit, paragraph 7.9. And the gist of that meeting, I'm just going to summarize to the court. The president would be given a state funeral, and the current president, Hichilema, would not preside over it, but he would be allowed to receive foreign dignitaries. He may be present at the funeral where foreign heads of state would be present, and Archbishop Banda would celebrate the Mass. And then it was also agreed that the tentative order or program would be drawn up and shared. And that program was in fact drawn up. And there's some controversy in the papers. The applicant initially said, we drafted the program. The respondents then retorted and say, no, we drafted the agreement or the program.
Mr. Scoop, just for me to follow, are you relying on FAA7?
Indeed.
Is that what you're relying on?
That's what I'm now taking the court to my level. That program is extremely important for two reasons. Firstly, it was drawn up by the respondents, and secondly, following further negotiations, the parties agreed that that program will be implemented. And what we say is that it is exactly that agreement that we rely on. The agreement that FAA 7 be implemented. And it is that